Did a Trump-appointed federal judge catch the Department of Justice giving Hunter Biden a sweetheart deal? That's actually a complicated question. And regardless of the answer, which we will get to, there are a lot of misconceptions going on about the delay in Hunter Biden's criminal plea deal, which sounds like the perfect opportunity for me, America's attorney, to drop some knowledge about the rules of the game. So let's break it down. First, let's talk about exactly what led to Hunter Biden's charges. Hunter has been the focus of a federal investigation for years, and he's been the object of intense internet conspiracies for just as long, or maybe longer. Throughout the course of the federal investigations, a few things came to light. As you know, the focus of the plea deal has been on Hunter's tax fraud charges. According to the charges levied against him, Biden failed to pay over $100,000 on 2 separate occasions. Ugh, I hate when that happens. He did it once in 2017 and again in 2019. Now, the allegations from the U.S. attorney are that Biden's actions constitute willful failure to pay federal income tax under 26 U.S.C. Section 7203. Now, obviously, a willful failure to pay is more significant than just miscalculating or being ignorant or doing what I do, which is forget to put a stamp on it. And yet it's still just a misdemeanor. But what a large misdemeanor it is, because in addition to needing to resolve the underlying indebtedness, Uncle Sam gonna get his, you can also pay a fine of up to $25,000 and spend up to 1 year in prison. That's pretty intense for a misdemeanor. To earn his second charge, Biden committed a little something called illegally possessing a firearm. The operative statutes here are 18 U.S.C. 922 G3 and 18 U.S.C. 924 A2. How many of my viewers right now have ever applied for a gun purchase license? Let me know if you have down in the comments. For those of you who haven't, or for those of you who applied but you didn't really closely read the background check information form, there's a question on the application relating to the use of illegal drugs. It's pretty public knowledge that Hunter Biden has struggled with drug addiction in the past, leading investigators to believe that he lied on the gun application. To be clear, Biden appears to have been a regular user and abuser of, at least at a minimum, cocaine for many years. According to the Biden family, Hunter beat his drug problem a few years ago. But according to the U.S. Secret Service, Hunter was on a very short list of personal guests at the White House a few weeks ago for the 4th of July, and after he left, agents found cocaine in the White House. Now, I guess the argument would be that he carries it around with him to show everyone he's not using it. Maybe. That he took some of the coke out to show his dad, hey, Pa, look, I won't be snorting this before we watch the fireworks together. And then he left it on the coffee table. Amazing. TBH, Hunter may not be out of the drug woods just yet, but if he's trying to Hansel and Gretel his way out, then dropping lines in the White House seems like it could be part of his recovery strategy. IDK. Let's break down 18 U.S.C. 922 G3. It shall be unlawful for any person who is an unlawful user of or addicted to any controlled substance as defined in Section 102 of the Controlled Substances Act, 21 U.S.C. 802, to ship or transport in interstate or foreign commerce, or possess in or affecting commerce any firearm or ammunition, or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. Let me simplify this. If you bought your gun or your ammunition and you didn't make it out of spare parts in your own house, this statute can apply to you. Section 924 provides that the punishment for the offense can be up to 10 years in prison and a fine of up to $2,500. And just think about how these two punishments are so different for a second. If you willfully don't pay taxes, the monetary penalty is up to 10 times the monetary penalty of a gun charge. But the time in prison is up to 10 times the length for the gun charge over the tax crime. These offenses are being policed in very different ways. Clearly, the people who wrote the laws, aka the US Congress, think that the tax charge is white collar and not dangerous, and that the gun charge is nothing but dangerous. And yet, here we have Hunter Biden qualifying for both. He's a two-sport athlete. And I don't say allegedly in this instance because, as you know, he tried to enter a guilty plea for these charges. Now, had he succeeded, he would not have gotten any jail time, which is probably one of the reasons that he was eager to say, yes, I did it. Because it was just going to be probation. And some people were in an uproar because a federal gun charge. Shouldn't he get like life without parole? Well, not exactly. Of all the gun charges outlined in Section 922, his was the most milquetoast. I mean, he didn't do anything wrong with the gun. It was just that he's not qualified to possess one because of his, drug problem. He has that cocaine with him that he's never using or whatever. And at least for now, he's a first-time offender. So actually, no prison seems about right. These charges led to the negotiation of a plea deal that made headlines as it simultaneously came with an attempted guilty plea from Biden. Every plea deal is the result of a negotiation between the prosecutor and the lawyers for the defendant. But like an agreement between siblings who've been assigned certain responsibilities or tasks by mom or dad, it's not valid until mom and dad look at it and say, okay, that works for me too. And in this instance, of course, we're talking about the judge. Judges act as gatekeepers of criminal pleas. Are they fair to the defendant? Are they fair to the victims? Are they in keeping with the purpose of the statute? And the judges vary a lot in terms of what they will say is okay. Some judges very much closely scrutinize the deals that come before them, and they're hyper involved in the approval process. Ultimately, the judge has the final say. Some judges, less involved. If there's a lot of trust between the prosecutor and the judge, for instance, like you might find in a small town where there's like one judge and one prosecutor, and they're in court multiple days per week for years. Now, at the other end of the spectrum is the Biden situation. First of all, you have a very high-profile defendant. That actually was not a pun. He's a high-profile defendant, not a high-profile defendant. Actually, maybe that was a pun. Oh, heck, let's just say, pun intended. There's news coverage, there's political intrigue, and of course, the U.S. attorney and this judge don't really have that level of familiarity with each other, and the years of working together in the courtroom don't exist for them. So the judge is gonna bring the comb, the fine-tooth comb, to Hunter Biden's case. And so when you see the splashy headline, Judge Rejects Biden Plea Deal, you get excited. Palace intrigue. What is happening? When is Trump pleading? But it turns out it's probably more an issue of a judge being good at being a judge than it is, say, the political machinations of the super powerful, or of a Trump-appointed judge exacting revenge on his political rival. Let me explain. The plea that the U.S. attorney and Biden's counsel brought to the judge was a Rule 11C3 deal. What's that mean to you and me? It means that the judge is not granted a blue pencil when looking at the deal. Now, normally a plea agreement is really like a three-party agreement between the judge and the prosecutor and the defendant. And the judge has a say in things. In fact, and this is especially true in federal court, the plea deal normally can be modified by the judge. The prosecutor can recommend a sentence, the defendant can agree to it, but the judge can alter it. But not under Rule 11C3. Instead, pleas under this rule cannot be modified by the judge. They're either approved or not approved, and that is the end of it. So why did this judge reject it? There were two issues, one of which was kind of resolved in court, and the other she asked for more briefing on. First, as many people know, Biden may or may not have been an illegal, unregistered foreign agent. Kind of a big deal. Or totally a hoax. I can't tell. But the judge asked if the plea deal took the potential criminal charges for that crime under the FARA off the table. Biden's lawyer is like, absolutely. The U.S. attorney is like, not a chance. Uh-oh. So they get a recess. That's where the lawyers talk in the hall away from the judge. They come back in and they announce to the judge that yes, in fact, he may still be charged under FARA. Well, that's an uh-oh moment for Biden. But they press on. The real deal killer for the judge was the fact that Biden was looking for probation and not jail on the gun charge. Okay, but how's that gonna work? Well, he needs 2 years of, as Bruce Rivers said, pun intended, I'm sure, keeping his nose clean, and the charge is dismissed. But the deal seemed to appoint the judge in that courtroom, as his de facto probation officer. They wanted it to be her responsibility to make sure that Biden never got into any trouble in any court, anywhere. And if you think that's weird, that makes three of us. I think it's super dumb, and the judge thought it was, questionable. You know, judges can be so reserved sometimes. The judge's concern, notwithstanding the fact that she is super busy with her lifetime appointment as a federal judge under Article 3 of the Constitution, is that the position of probation officer is under the prosecutor, and the prosecutor is a position inside the executive branch of the government, and not to belabor the point, but the judge is in the judicial branch of the government, and her job is to always be in the third branch of the government and to never be in the second branch. And she wants them to explain in writing why she should no longer care about that sacred government principle called separation of powers. And all I can say to the lawyers working on those briefs is, good luck, lawyers, you're gonna need it. They're never gonna get the judge to agree to be the de facto probation officer or the de jure probation officer or any other kind of probation officer. Not in this life. Here's the upshot. They will work this out. They'll get a deal that gives Biden a regular probation officer. And then the judge will approve that deal. And then he'll likely never get charged under FARA, because if they were gonna do that, they would have already done it already. Don't hold your breath. Hunter's walking away from that potential charge, which some will love and some will hate, and others won't care. Well, what camp do you fall in? You got me. That's right. I'm trying to get you to drop your pro se opinion down below in the comments and let me know what you think. What's going on with Hunter? What do you think of his guilty plea situation? I'll wait right here next to these super cool videos that you should totally watch, and I'll see you soon. Bye.